fourth and final session of this conference on the digital border. If I yell loud enough, somebody will, yes. My name is Tim Webster. I teach international and comparative law here at the law school, and I'm privileged to welcome you to, as I said before, the fourth installment, the fourth panel of the day, where we will be discussing the Trans-Pacific Partnership, which I will explain in a little bit. I am delighted to be moderating a panel with three distinguished panelists, and thank them and all for attending this final session of the day. Let me begin with a quick introduction of our panel, and then I will make some introductory comments about the TPP. First, to my far right is Adon Katz, who is a cyber lawyer and co-founder of Pseudo-Room, a creative enterprise and hackerspace in Oakland, California. I know Adon from college and from graduate school, and he still associates with me, which is a nice thing. Before he took up his entrepreneurial job as a founder of a hackerspace in Oakland, Adon worked at Yale Law School's Information Society project for many years, and also at the Electronic Frontier Foundation, which is one of this country's leading NGOs in the field of IP and information technology. In the middle here, we have Professor Justin Hughes, who is the William Hannon Distinguished Professor of Law at Loyola of Los Angeles Law School. Before assuming his position at Loyola, Professor Hughes taught intellectual property and trade law for over a decade at Cardozo Law School in New York. And he has also advised the Obama administration on a number of IP initiatives, and has a very international perspective on the TPP and on international trade more generally. Has worked in various capacities, whether as a clerk or as a lawyer or as a consultant on 5 continents. Finally, to the left is Professor Sam Trossaugh from our partner school up north, the University of Western Ontario, or Western as it's now being rebranded. Professor Trossaugh has had many lives. He started as a tenants' rights lawyer in California as a property professor. I'm obviously very delighted to hear that. He was then a law librarian at Bolt Hall for many years, and then finally he is, after getting his PhD in information science, he is a professor of law and professor of information and media studies up at Western. Now, having introduced the panel, let me turn briefly to the Trans-Pacific Partnership, or TPP. We've heard a lot about this over the past several hours and last night as well. But just some basics about it. This is a trade agreement that is currently being negotiated by 12 states, including the United States and Canada. So it's topical for this conference as well. If and when it's completed, and we're always told that it's going to be completed soon, we've been hearing that since 2011, it would create the largest free trade agreement in the world by sheer size. This basically from 4 continents, Australia and New Zealand, Japan and Vietnam and Asia, the NAFTA countries in North America, and Chile and Peru in South America. And it would also cover 40% of world trade. This is a very, very important agreement, if for no other reason than by its sheer size. The agreement itself started out as an agreement between New Zealand and Chile and Singapore over 13 or 14 years ago, and since that time has gradually expanded. The U.S. joined the negotiations in 2008. Canada, as we know from Ambassador Dewar, started negotiations in 2011, Japan in 2013, up until the 12 states we have now. And within those 12 states, and this is somewhat unusual for a free trade agreement, we have not only geographically non-contiguous states. Usually free trade agreements have some kind of geographic coherence to them, but we have developing states, we have liberal democracies, we have an party state in the form of Vietnam. We have Brunei and Malaysia, which are Muslim majority states that practice forms of Sharia law. We also have developing countries such as Chile and Peru. So it's a very heterogeneous grouping of systems, of economies, of ways of looking at. Now, we've heard a lot about the TPP, as I said, and one of the things that gets repeated is that this is to be a comprehensive and high-quality 21st century trade agreement. That's something that, those words were among the words that John Melly used last night in his remarks, and they're ones that are repeated again and again. So what do we actually mean when we say a comprehensive, high-quality agreement? I want to address that for a couple of minutes, and then I'll start by posing some questions to our panel here. First, comprehensive, this trade agreement actually covers a huge range of sectors. And one question I'd like to pose is that a desirable state of affairs? We call it a trade agreement, but it actually includes a whole bunch of things in addition to trades in goods and trades and services, things like cross-border investment, things like customs cooperation, things like environmental protection. We know that there's provisions about logging and fishing and things like that. And of course, germane to this discussion about intellectual property. And we'll hear from our experts about what the IP provisions of this agreement look like. Now, so that's the comprehensive part. By the high quality or high standards part, government officials and public discourse more generally seems to refer to the very high standards that certain countries, the U.S. chief among them, are seeking to put into the agreement. And so words like high standards or sound good. We all want to abide by high standards. We want to have high ethical standards and high academic standards. But we also should ask, is it desirable for a trade agreement to have high standards? And what does it actually mean for a trade agreement to have high standards? Are the high standards that the U.S. is seeking to include for IP protection desirable? Is that desirable for the U.S.? Is that desirable for other countries? We know that several developing members, negotiating partners here, have opposed some of the U.S. suggestions about IP. So when we talk about high standards, it may sound good, but that is going to be working to the benefit of certain countries and perhaps not to the benefit of others. So having briefly introduced what the TPP looks like, let me turn to our distinguished panel and try to mine some of their insights about the TPP and about trade agreements more generally. Let me begin by posing a question to Professor Trossaugh, in particular this idea of a comprehensive trade agreement. We know that trade agreements keep on expanding into new territories and new sectors, and I think it's an open question as to whether that's desirable, what kind of trade-offs there might be in that kind of expansion, whether that's going to lead to regulatory coherence, whether everyone's going to abide by the same standards, or, as we've seen with the TPP, whether that's just going to slow down trade negotiations. Nobody can agree to one thing, much less the 14 or 15 different sectors covered by the TPP negotiation. So, Ms. Trossaugh, if you could take a swing at that, please.
So let me start by thanking you all for having me here. This is a great conference. My general position, and I feel very strongly about this, and I've taken similar positions with respect to TRIPS, trade agreements in some of my writings. Trade agreements should not include intellectual property chapters. My position here is very simple. The IP chapter should go. We have a framework that was developed over many years through TRIPS as part of the WTO. I really think we have to let that play itself out. As a matter of fact, over 10 years ago, when the FTAA, a similar set of agreements was on the table, the Canadian government actually took that we're not going to table anything in the IP chapter because we just want to see TRIPS work out. So things have changed. Things have changed a bit. The thing about TRIPS that's very useful is certain flexibilities are written in with respect to certain things that developing and the least developed countries could do, and there is an enforcement mechanism in TRIPS. What we've seen post TRIPS is many time and again, usually with the USTR leading the effort. We've seen many proposed trade agreements that ratchet up the level of intellectual property protection. And again, when you say we're going to increase, we're going to improve intellectual property law, intellectual property protections, that sounds really good. Remember that with intellectual property, you're creating a statutory monopoly. And whenever you increase statutory protections, you're also increasing limitations on what people can do with respect to educational materials, with respect to seeds, with respect to medicines. And there can be downside social costs. One of the reasons why I really want to stress that the IP section should come out is the possibility of loss of national sovereignty and integrity in this area. I think different intellectual property policies might be better for different countries in different stages of development. And to say that we're going to take the United States model, part of the United States model, and impose it on the rest of the world, I don't think is good international policy making.
Great. I don't know if either of you would also like to respond to that, or I can begin with another question.
I can respond.
Sure. Yeah. Go ahead. Go ahead. That's part of the.
So I served many years in the government as a treaty negotiator for the United States, but at the World Intellectual Property Organization, not in WTO or trade matters. So I guess I would respond to Sam's observations three ways. First of all treaty negotiations are losses of sovereignty. That's what it's all about, right? You can phrase it as you want to, but it is some surrender of your sovereign capacity to act and decide. Now, Sam's critique, which was interesting, is we worked very hard on TRIPS in the late 80s, early 90s. We have TRIPS. That TRIPS is built into the WTO, so we should see how it plays out. But Sam, I'd ask you, that argument would mean no bilateral or no plurilateral trade agreements on anything, because you could say throughout the WTO, we have the sanitary and phytosanitary agreement, we have the technical barriers to trade agreement, we have a whole lot of things in TRIPS in WTO. We should wait and let them all play out. So Sam's argument is a valid point, but it casts a very broad shadow, right? So you have to pick out some reason why you think IP should be taken out. And I don't see that reason for IP to be taken out, because as someone who teaches international trade and teaches intellectual property, the trade in intellectual property goods is enormous. It dwarfs many categories of traditional trades in goods and services. So particularly for economies in Europe, for the United States, for Japan, for Canada to a smaller degree, that trade in intellectual property is a very important part of the international globalization picture. So I don't see a reason to take it out. Now, Sam is completely right that these systems, these proposals are typically TRIPS plus, what are plus or WTO plus, meaning that the more developed economic partner in the bilateral or plurilateral arrangement is trying to get improved deal that is typically more pro-IP. One shouldn't blame it wholly on the United States, because when the European Union goes around doing free trade agreements, what they want is massively strengthened protection of geographical indications, an area of the TRIPS agreement where they came up short because the Canada and the United States and other New World countries opposed them. I would also say that one thing that's generally not recognized in these FTAs when they do have a ratcheting up of IP is they also introduce some limitations, because what's characteristic of all the U.S. FTAs is we ask for limitations of liability in the copyright sphere for intermediaries on the internet. So that's an example where I don't think full credit is given that there is it is a give and take. It is asking countries to adopt a lot of U.S. norms, but it's norms on both sides. Sam is right, though, that the U.S. doesn't ask countries to adopt norms in the sense of asking them to adopt all our exceptions and limitations, just our exceptions and limitations that benefit Google. So, did I say that? Okay. So that would be my response.
Please.
Yeah, I also wanted to touch on the general issue and the title for redrawing the digital border. And I just wanted to point out that that's kind of a difficult thing to wrap your head around, what a digital border is like, and wanted to introduce a couple of images to, because it is a challenge to the imagination when we talk about internet law and internet governance. And since Terry Pratchett recently died, he has a great short story called The Troll Bridge, where Cohen, the barbarian, troll, as in the guy under, and Cohen, the barbarian, late in life, comes to find a troll who's been under this bridge for a while, is now 87, and they start talking about how things used to be and how it's so much easier to navigate, control over the bridge. And the troll's wife says, there's no future in just jumping out from under a bridge. Then they start talking about what we would call maybe vertical integration in other aspects of controlling mills and other ways of crossing that bridge. I think that the reason that that's maybe not troll in itself and desire to not be outdated, the reason it's relevant is because we're actually asking, and it may not necessarily be the best to enforce these kinds of borders. When you think of a digital border, it is, it does lack a certain physicality, and I think to continue, proposing in your imagination, imagine that digital law had the same sort of subtlety in its enforcement as TSA agents have when you cross the border, when you arrive at the airport and take off your shoes. In some countries, you don't have to take off your shoes, and it was originally 3 ounces that you were able to carry in a little thing, and then it turned out 100 milliliters was what the general size was in Europe, so it became 3.4. And the arbitrariness of it and the ability to navigate the subtleties of what goes on in information and knowledge products is something that is better left to the existing judicial bodies countries, and I think we should keep it away from TSA agents.
Excellent. Good. Thank you for that. I want to pick up on something that that Justin just mentioned about the U.S. standards or the U.S. views about the Trans-Pacific Partnership. This obviously is the Canada-U.S. Law Institute conference, and so I want to make sure that a Canadian perspective on this is also heard. Earlier today, Ambassador Dewar said, underlined the importance of TPP to Canada. At the same time, he said that when Canada started to join the negotiations back in 2011, he noted that Canadian negotiators had a rough time, that's a direct quote, with regard to some of the IP provisions in general. So I'm wondering, again, if I could pose this to Sam here. Is there a generally accepted view among Canadians, obviously not necessarily the Canadian government, about IP protections? I'm thinking in particular about a recent NAFTA arbitration case where Eli Lilly, the American drug company, brought a NAFTA arbitration against the Canadian government because the Canadian government rejected 2 patent applications that Eli Lilly had posed. Unhappy with that result, Eli Lilly then turned to the NAFTA arbitration process, and that's ongoing. But I'm wondering if there's, if you have a sense, or if there is, perhaps multiple perspectives from Canada about this idea of strengthening copyright or patent or any other kinds of ideas.
There's no one Canadian perspective, just like there's no one U.S. perspective. You've got divergent opinions within Canada and within the United States on just about all of these issues. Canada has been through a policy-making process in the area of copyright that goes back to consultations in 2001, culminating in a massive rewrite of Canada's copyright law in 2012. We also have 5 Supreme Court decisions, the Pentology, that came down in 2012. There's this feeling that even though copyright has been a very contentious area in Canadian policy, it's settled down a little bit, and we're looking at what might be a more stable regime right now. So to read in these leaks that there are all these new rights that are being proposed, the term is going to be extended. It's a little disconcerting to go through a very, very successful, I would say, and democratic consultation process, such as we had in Canada, only to find it being potentially upended in a secret process after we've gone through all of this from the courts. We've also seen decisions from the courts in the United States. For example, this morning we heard about Kirstang. There was a provision in one of the earlier texts that effectively would have overruled Kirstang. So basically, I think that what's happening is those that want to push for a much heavier rights holders position are using the international trade venue as a runaround, as a workaround to decisions that have been made by democratically elected institutions and courts. And I really have a problem with that. It's called policy laundering. And then it's going to come to Congress and people can't even make changes if fast track passes.
We'll talk about that in a minute. I'm wondering if either of the other panelists have comments about, not necessarily about the Canadian perspective, but about these provisions that are seen in the leaked, the WikiLeaks draft agreements of the TPP, and in particular, the increased or the potential increased copyright protections, patent protections, and so forth. I don't know if either Justin or Adon would want to take a swing at that.
Yeah, the alleged copy available at WikiLeaks does actually have notation as to opposition on certain terms, and Canada is identified as opposing some of the terms. And so just to bring it to specifics, since you've asked, in terms of intermediary liability, which is in QQI1, there's a difference in regards to the termination necessary of repeat infringers. Content blocking under the same intermediary liability with a privacy override, significantly departing from Canada's protection. Statutory damages in QQH4X. Criminal liability for copyright in QQH7. Including the anti-circumvention provisions and expansion of enforcement of trade secrets under QQH8. So there are, in fact, rather than just hand waving, there are very specific areas where, even though there may be exceptions introduced, the subtlety and difference in language creates this sort of expansion, or if one is friendly to it, evolution of exclusive rights types of intellectual property enforcement, as opposed to the high standards of exceptions and limitations, which is being developed in WIPO and other places.
Sure. Justin, do you want to have a crack at that?
Well, I think actually, whether it was Tim's question or whether it was my panelists' responses, has really opened up the full range. Because when I look at the criticisms of the TPP, I really see, at least the IP chapter, I really see 4 different kind of lines of critiques. There are 3 process critiques, and there is then the substantive critiques, and of course there's a variety of the substantive critiques. So let me just give you my framework for how I think of the critiques. The first critique, of course, we heard, Sam raised it last night, was it's a secret process. And that is a critique that we can probably pretty quickly get our handle on and discuss. The second critique is one Sam just mentioned, and that is the kind of international norm-making process frustrating domestic democratic processes. And that we can probably have a much richer and much more robust discussion about. I understand now Sam gave that kind of and Canada's tired. My policy space is tired, which is a legitimate, we've been through a decade of this, we're tired, let it rest. But the general critique, the more general critique for all of us is, we have democratic processes that form legal norms, and yet there is this international level that is forming legal norms, and then those legal norms are being pushed back on us. What do we think of that? I think that that's a legitimate thing for all of us to be worried about, but if you're worried about it, then don't like it when it happens on human rights and environmental law and gives you norms you do like. Don't let your objection mask what is actually a substantive objection. And let me give you an example of that. In 2013, we successfully concluded a multilateral treaty establishing exceptions for the blind. Now, recently, one of my professorial colleagues from a school that's not here wrote me and said she didn't like these international processes establishing legal norms that in the frustrating the domestic political process. I wrote back and said, Sharon, well, you should know that the treaty we negotiated for the blind will require a change or clarification in United States law that special format copies can be exported abroad to blind people in other countries. By your standards, you should hate me because I negotiated that, subverting America's democratic process to decide whether or not we are gracious enough to share format copies with the blind. If you hold that as the critique, be consistent. Say, no international norm formation until we've all agreed upon it in our domestic democratic systems, which means no international legal norms will be formed again. So that's process critique number 2. The third process critique, which is related to it, is we don't like small clubs making norms when they should be done at the multilateral level. And that's a legitimate critique too. But, you know, you can take different perspectives on that. A lot of us who've served long time in Geneva would say the multilateral process is most of the time broken or limping along. And if you're going to make it say it all has to depend on multilateral and there can't be any regional and plurilateral advancement of goals, whether they are environmental goals or labor goals or IP goals, then, you know, we're going to have a very slow 21st century. And then there's then we were going to the substantive critiques, which both my colleagues had, and, you know, we can spend a lot of time talking about those. There is a set of copyright critiques that Sam could make of strengthened copyright protection. I do think, and this is where Sam and I disagree, that the copyright component shows a liberalized view toward exceptions and limitations, which is a good thing. I would think that if you were criticizing the United States most, you would criticize them on the patent components, not the copyright components, because there's much more in the patent sections that are a U.S. ask on patents. But there's a ask on traditional knowledge from Chile and Peru, developing countries who want movement on a form of intellectual property, and they have an ask too. And in geographical indications, there's a whole set of provisions which represent, in essence, a New World attempt to push back the European Union, where you find that Australia, New Zealand, Canada, the United States, Chile, and Peru are all on the same page, and the only one of the TPP negotiating countries that probably is most against that would be Mexico. So Sam is right. The U.S. proposed life plus 70, but you should all know that's not by Sam's lights, that should not be the most outrageous proposal. Mexico proposed the copyright term should be life plus 100. Why? Because that's Mexican law. When you go into one of these negotiations, you don't propose something that isn't your law. You propose your law because, at least facially, you have to believe in it, right? So if a country has laid down a bunch of things and said, this is what we want, well, you got to figure out what do they really want, right? Because diplomatically, they have to say, what we want is our law, right? Now, there are a few places, rough edges, but generally speaking, what we want are our law. So I'm not surprised at all. The Americans say we want life plus 70, say we want life plus 100. Perfectly reasonable. Do the Mexicans think they'll get it? No way. Do the Americans think they'll get lots of things they ask for? I don't think so. But if the Japanese asked for that, they're much more likely to get it. Now, why? Why? For reasons that aren't related to IP at all. Because this is a trade deal, not an IP deal. And frankly, the United States doesn't bring a lot to offer into the TPP. We already have very low tariffs as far as all these countries are concerned. But the Japanese, that's a different story, right? Their agricultural tariffs are stunningly high for a lot of these countries. So if the Japanese want some things in patent law, that's where I'd bet my money that it's going to happen. To give you an example, the highest tariff product category for Japan, which is dairy products, so talk about what Canada might be willing to do, is 78% tariff rate. There are no Australian, New Zealand, Canadian dairy products in Japan, I'd bet, with 178% tariff rate. But if the Japanese say, hey, we're willing to move a lot on that, then if you're in New Zealand, you might say, I'm willing to move a lot on IP. So it's all part of a, what did the ambassador call it earlier? Full something contact sport?
Contact sport.
Full-bodied contact sport.
Just really briefly, you mentioned the section on limitations and exceptions as something good and positive, and I just want to point out, I think it's a meaningless section, and it's window dressing, and it should not be given any attention, because it's not binding. It doesn't mean anything. The language is each party shall endeavor to, which is precatory. It's very different than the actual direct language in the right section that says each party shall provide.
And
So-
Sam is right, but the Universal Declaration of Human Rights is non-binding. And anyone who teaches public international law knows that that doesn't mean anything. It's tremendously influential.
Did you want to respond to that? No.
No,
Okay,
I'll
good.
leave that be.
I will simply add that if you thought dairy was bad, Justin, you should know that Japan also imposes a 777% tariff on rice. So by that standard, dairy is,
So Vietnam
anybody.
should be willing to do a lot.
Yeah, exactly. A couple of you have talked about concerns with the democratic process in the TPP negotiations, and we've talked about secrecy. Sam talked at length about the judicial decisions and the legislative decisions that Canada has made. And I'm wondering, we also talked earlier, or I should say, Ambassador Dewar mentioned Trade Promotion Authority and that wrinkle that has yet to be worked out in this country as well. And I'm wondering if any of you would want to respond or have insights as to whether we think President Obama will get fast-track authority from this Congress, or if he does, what that'll mean. If he doesn't, what that means as well. So does any of you have any thoughts about domestic democratic issues in the United States, apart from what we've already heard about in Canada?
I'll go first on that. I think if the administration doesn't get fast-track authority, it will have nothing to do with the IP chapter. That's what I would say.
The likelihood of putting that aside, I would say that there's room for reform of the process, reforming the trade advisory committees to have more diverse representation would be one, strengthening the congressional oversight and negotiating objections, as was pointed out in regards to environmental and labor concerns. There actually are negotiation objectives that are outlined. Beforehand, there is no such existing, I would call, access to knowledge equivalent, which I would say, if there were to be fast track, should exist. They should institutionalize transparency guidelines, and I think it should be open to the general public. I think there's a procedure in place under the State Department in the Circular 175 procedure. I think having seen 4 million comments on net neutrality, I think that it is a constitutional moment for something like this, and in regards to the internet, that the public should get to be advised and have some level of consent in regards to this kind of treaty making.
Good. I want to open it up to comments. But before I do that, I want to just go back to one thing that Justin was talking about, and that is the availability of flexible arrangements for developing countries. You talked about traditional knowledge that Chile and Peru have put on the table as something that they want as they envision IP. And I'm wondering if you've heard of other forms of flexibility for developing countries, whether in South America, in Asia, or is this going to be a take it or leave it deal, or is there going to be some kind of massaging, some kind of timeline that may be different from different developing countries?
I think I know where you're getting that question.
Okay.
So I don't know if it's in the document, but I can't speak to my sources. But I'm surprised. First of all, you need to think about the TPP club, right? So the TPP club is developed countries, some countries that are high income developing countries like Malaysia and Brunei, right? And then you've got at the bottom, far at the bottom, Vietnam and closest to it, but still much higher up, Peru. And so I wouldn't be surprised if there is some buckets that are established in terms of transitional arrangements, giving Vietnam more to meet the standards of whatever the IP chapter is, perhaps allowing Peru to reach also to participate in a transition arrangements. I am told, and I'm not sure how much this is discussed, but I am told that at the recommendation of some of the more civil society components that do consult with the government, that the U.S. government had proposed a kind of transition arrangements based on development metrics, that Vietnam would not have to meet certain elements until it reached certain development metrics. That went over like, floating that idea, it went over like the in the 80s. It sank like a rock. No one wanted that at all. So if there are transition arrangements that are done eventually, I think they'll be firm in terms of X number of years. But I wouldn't be surprised if that happens as a way of addressing some of the access to medicine issues, to say that a lot of the patent chapter would not apply until a country had a certain amount of time. Presumably, Vietnam is developing quite fast economically. So, and I also agree on the question of the trade advisory councils. That is part of the American trade policy development apparatus that be reformed. And if you want to talk to either of us afterwards, be happy to talk to you about that. I don't know the counterpart in Canada. Is there a counterpart to these kind of industry bodies that consult with Industry Canada?
Maybe Kai would know.
Yeah, so we have something called SAGINs, I believe?
No. There's no structural mechanism. There's informal consultations that go on all the time, but it's not formal structure.
We have a very formal structure, statutory structure, and there is and to USTR's credit, they do a great deal of informal consultation with anyone who wants to talk to them, but the formal structure does give significantly different access to those who can participate in the formal structure, and that is something that needs reform. And I know a lot of people in the White House feel that way too.
Significant differences, those actually see the drafts, and everyone else who comes to visit doesn't. I mean, that's important to point out.
Yeah, if this isn't the real draft.
Yeah, if it is real. Yeah.
Good.
There's a 2014 version. There's a later version.
Yeah.
Good. I have asked all the questions that I am sought answers for, so I'd like to open it up to the floor and see if any of you would like to pose questions to our panelists. The microphone will be up to you shortly, sir.
I want to respond to your point about that every treaty.
I'm sorry, do it again.
Your mic's not on.
Yeah, your mic's on.
Now it's working. Okay.
Wow, now it's on.
Okay, so I want to respond to your point with respect that international treaty has, every binding international treaty has some democratic deficit problem to it, and I totally agree with that, but I think I would different conclusion from that. So from that observation, the conclusion that I would draw is that, therefore, we should be very careful before we enter into those treaties. So first, I would want to identify why is it that we need to have an internationally binding norm? Is there a serious collective action problem that requires this collective solution? And then if the answer is yes, to identify that narrow issue that requires this collective action, acknowledging that there is a democratic deficit problem to solve it on the international level, and from that I would require to adopt a process that minimally impairs this democratic deficit. And I think that the Treaty for the Blind, it could be a good example for that. Well, first, I'm not sure on the first question, is it really necessary? But let's assume that maybe there is, that we need a treaty for that. I think some developing countries thought that they do need a treaty for that. But then the process was, in that regard, quite unusual and extraordinary in the way that it did try to to overcome the democratic deficit. So that was, no, there were everything was transparent, everything was high consultation, deep involvement of a lot of civil society, including live tweets from the from the negotiation, including live tweets about your arguments with someone else, and the result was one that eventually now everyone is proud about that. But that's nothing like what we know about the TPP. So there's a big difference between the two.
Well, I assume, at least for the United States, and I assume this is true from everything I've ever heard a Canadian negotiator say, and it's also true from everything I've ever heard a Brazilian or an Indian negotiator say, is that no country with a developed consultative process and a sophisticated law on that issue comes to the table wanting to change their law. Right, so frequently you're trying to craft language that lets each that meets your collective goal, but lets each country go home to their minister, to their parliament, to their Congress. Well, we won't really have to change our law, or we won't have to change our law very much, or just the tiniest little tweaks. So, but for a lot of those countries, while we ideally would like them to have robust democratic and/or consultative processes at home, they simply don't. And it's a legitimate query to say, what do we want to say to them? Now, you said a narrow issue that requires collective action. Let's say that you and I are put in the shoes of negotiating for Vietnam. I'm going to assume, I could be wrong, that the Vietnamese don't have sophisticated consultative processes and don't have much in the way of indigenous yet. So Vietnam is going to be making some trade-offs, right? And they're going to be made at the very top by people in Hanoi who are going to decide we're going to get enough benefit out of this on trade in terms of increased income for our country, raising our per capita income and lifting our people out of poverty, or a certain percentage of our people out of poverty. And in exchange, we're going to give this to the Japanese and the Americans and the Australians and the Canadians. And that's what they're going to decide. And I can't criticize that. They may say there is no problem that requires collective action solution at the international level, but some big economies have offered me a deal, and the deal involves some trade-offs, as that's the definition of a deal. And if they decide to take it, I can't say that there's been a failure of the political process, either at the international or domestic level. Does that make sense? No? Not to you. You think there is a failure? Okay, well then
Why
let
don't
me
we table this for
let me
one.
let me put it to you this way. If I didn't take the deal to increase the per capita income of the Vietnamese people and I was in the Vietnamese leadership, I would consider that a failure myself.
I think we have time for one final question, please.
I thought this was
So on that, yeah, I have a broad question, but a comment. But first, let me just say,
45 minutes in.
For anyone here in the room who thinks that the consultative organization the U.S. has established have a significant role in
I'm not sure his mic.
I can't hear you.
Can you turn the microphone off?
I killed it. You got another one? Okay. I have this effect on mechanical and devices.
This one I think works.
Yes. Is that an electromechanical device or just an electro?
I've served personally on one consultative group. I've been counsel to 4 corporates, members of another, and a labor union member of a 6th. And those of you who think that those groups affect significantly U.S. negotiating positions probably also believe that grand juries tell prosecutors who to indict. They don't. They do not. The U.S. government runs those bodies, and I can tell you that, well, leave it at that. The one thing I would comment on here about the nature of the discussion here has been, I think you need to keep keep sight of what TPP is about. TPP is first and foremost about the new ways in which trade is being conducted. Yes, there are some tariff reductions in agriculture with Japan. Yes, that's significant. But mostly the TPP is about the behind the scenes, and intellectual property is a major aspect of that. There is a reason for that. And that is trade is being done differently today, increasingly. Trade is no longer about I make it here and I'll sell it to there. Trade is about establishing global value chains. It is about directing investment flows by multinational corporations and where they go. The idea of the intellectual property, the idea of an investor state, the idea of disciplines on state-owned enterprises, the idea of all of this, to the extent they ever can do it, and I'm a skeptic of regulations, it's all about making it more possible for foreign direct investment flows by multinational companies to go to the countries that are members of the agreement. When you start talking about the concerns you have, remember there's stuff on the other side. If global value chains reduce costs, avoid conflicting regulations in countries, have better protection of intellectual property, consumers around the world benefit. More benefit to the countries who are involved in this, who get the foreign direct investment. The big problem that I've always had with TPP is not that it's a bad thing or any of the reasons you're talking about, except for the one about its being a club, which is primarily of developed countries and high-end developing countries. The question that I have in mind, that I pose to you is, where do you go from TPP for the great majority of the world? Now you say TPP represents 40% of the world's production, TPP plus TTIP represents 72%, whatever. How much of the world's population does it represent? Very small. 20%, 22%. What that says to you is that the developing world is on the outside looking in. And what's the mechanism? Where are we going to go to extend the benefits of TPP to these other countries who didn't want, understand, many of them didn't want these kinds of things like on intellectual property and investor state dispute settlement and state-owned enterprises. Now, a lot of them do, and all over the west coast of South America, all those countries in TPP. There are a lot of developing countries who will join in TPP, but there are a lot who won't. And the concern that I have about the TPP is you're getting to a bifurcation of the world economy that's already there, and you may exacerbate it if we don't find a mechanism to multilateralize the TPP and the TTIP. I think industries, people see this as a big plot by multinational corporations. Granted, but probably a good plot, in my own humble opinion, if we can find a way to multilateralize it. But right now, there's no plan for doing that, and that's a big open question that nobody's thought about. So I will leave it at that, and I have some concern with saying that we should not impose upon developing countries or other countries what our law is. The question is, should we have uniform rules for doing business to the extent that we can do so? You may say yes, you may say no, but there are arguments on both sides of that question that I urge you not to overlook.
Well, it was originally started talking about this as a century agreement, and I agree that it's a 19th century mentality of a colonialization of law that is the process by which it's being done. And I think the answer to the question of how will it perpetuate, it will be shoved down the throats of the rest of the world is most likely the case, as addendum or attached to other negotiations. And so this is basically norm setting for the whole world, but doing so in an information feudalist way.
I mean, why is India and China? Well, I know it's the Pacific, but why is India and China not in here? I mean, I think what the United States is trying to do is just create sort of it's the momentum theory of international trade agreements, where you sort of roll along and you do one. It was admitted by the United States that CAFTA was something designed to help spur along the ultimate drive to the FTAA. Well, I think it would be better to have a process where everybody can be involved from the start. Yeah, I know.
Yeah, it would be better, but will it happen? And so, to answer your observation, I would say that let's assume the TPP gets done. Let's assume you're correct that other countries in the Americas join. Korea joins. Eventually, Philippines joins. And do I, as a trade person, think the play is? Look, Doha is dead. I'm stunned that no significant political leaders in the United States, I don't know about Canada, is not willing to say Doha is dead. It's treated like a zombie that just cannot be put down, and it's down. But when you put it down, you got to say what happens next. What happens next, a brave political leader would do, is say what happens next is we have to start a trade round that not just talks about ag and tariff and non-tariff barriers to trade and investment, but talks about labor and talks about environment. And that brave person will then perhaps hold up TPP. I haven't studied the labor or environmental issues, and say, here's a place to start. And if that's true, if this is a mechanism to bring environmental issues and labor issues into the picture in a bigger sense, in a stronger sense, that I would think that would be a lovely development in my lifetime.
I would just add that we can't know what's going to happen until TPP has been around for 5 or 10 years. There is no teleology of international law. There are treaties that are passed, then people look at the results, and then they recalibrate. So investor-state dispute ISDS is one example of that. It seems to work. Now, as is pointed out last night by Mr. Melly, a lot of countries, including Canada, including Mexico, are like, do we really want to have ISDS? So I say you can't, there's no overarching trajectory. There are movements, and then there are reflections from different countries about how well it's worked out, and then you recalibrate. But we do have, I've been told we have until 4:30, so if we have additional questions from any members of the audience, I would welcome them. Please, Bruce.
Just as an outsider looking in, and having listened to talks on TTP and TPP and TTIP for now quite a few years, it seems like the second coming of the continental drift. I mean, nothing seems to happen. I mean, I guess maybe it's a reflection on how big an achievement something like NAFTA was, but in terms of that something actually got done, and you actually have a treaty in place that makes a lot of sense and has produced tremendous benefits. But, you know, it's very frustrating looking from the outside and seemingly seeing nothing much happening. You know, maybe it is, but I know these are problems that are difficult to surmount, but, you know, from a lot of outsiders looking in, it seems very frustrating, and that there's sort of sight. Can I get a comment on that? Is that a misreading of what the situation
You're sounding like
really
a millennial
is?
to me.
I beg your pardon?
You're sounding like a millennial to me. You want it now and you want it fully.
Well,
That's what happens. This is a digital conference, right?
We don't know the
It
answer.
happens right away.
Okay. So my response is it is frustrating because we don't know. We don't know where this is at in the process. In legislation, in Canada, you have your first reading, second reading, third reading, then it goes to the Senate. In the United States, it goes through committee hearings. You know where it is in the process, and you can follow it. And you can get some sort of idea where it stands in the legislative history. In a court case, there's a litigation docket. You know where something's going. You know where are you in pleading? Are you in discovery? Are you in trial? Are you in appeal? You know where you are. And this goes to the basic point of lack of transparency.
Please.
Yeah, I think that if for those of us who've taken a class in international law negotiation. It usually is that the negotiators try to keep information from each other and negotiate that way. And they're representative of the people in whatever country. In these cases, ACT and TPP, the information is being shared between negotiators, and the general public and the citizens of the individual countries are treated as the enemy and being held close. I think that's why nothing's moving.
Well, I don't think in international negotiations we try to keep information from each other. I'll about that. Before we went to a diplomat conference in 2012, American diplomats get these security briefings. So the security people come over and they're briefing our team. And they say something like, and you realize and be careful because you're being in an environment where foreigners are pumping you for information. And we walked out there and said, Jesus fucking Christ. Well, of course. I mean, we're pumping them for information and they're pumping us for information. That's what it's all about. So I don't think it's trying to keep information for each other. In fact, you succeed more that you actually disclose, here's what's happening, here's my hand, here's what I've got going on back home. But, you know, clearly this process should be more transparent, could be more transparent. And I think it's just a legacy of how trade negotiations have gone on in the WTO system that it is not more transparent. But having said that, in a non-transparent process, I think you would agree with me that the longer it's drawn out, the better. Because the longer it's drawn out, the more de facto transparent it becomes. Where do the WikiLeaks documents come from? Don't know. In ACTA, lots of countries were leaking versions of the documents, right? And in a formally non-transparent process, at least the longer it is drawn out in democratic societies, the more de facto transparent it becomes. And if you said, well, I wish the TPP had been done in 18 months, let me tell you, my bet would be anything like the TPP done in 18 months would fail. It takes, particularly something this big, it takes years and years of news stories and everybody feeling like they went in and talked about it. And even if you aren't in the Trade Advisory Council, I'm thinking of some of the civil society people I know who aren't in the Trade Advisory Council. Maybe someone in their spirit should be, but they've had umpteen meetings with USTR. They may come out fuming, but you know, they've had those meetings, and there is I guess I'd say for a non-transparent, a process that is formally non-transparent, it's better for it to be drawn out and long, because the more drawn out, the more de facto transparent it has to become.
I would add that the Canada-U.S. free trade agreement, which became NAFTA, took about 5 or 6 years. WTO has been going on, the Doha round has been going on for 14 years. Here we have 12 parties from all over the Pacific. We can assume it's going to take quite a bit longer. And then to piggyback on Justin's point, the Affordable Care Act took about 2 years or so to pass, and we've spent the last 5 years trying to undo it. So maybe there is something to be said for a cyclical process where everybody gets to have his or her concerns raised in a legitimate way.
But if you correlate it to the EC, if they spend a bit more time thinking about it at the time they put it together, they might not have quite the same problems they have now. But
Sure. I think we have time for one final question, if anybody would like to add one more comment to our panel.
We have.
Great. Thanks.
Thanks. My question returns to the intellectual property subject. And assuming that this happens in 2 years, 5 years, however long it takes, then you turn around and start implementing. In some places, actually enforcing some of these regulations is already a problem, even though there are laws on the books. How does having an agreement like this make that any more effective?
I would not argue that it does, so I'm not sure I can answer that question, because I don't think it does. I think what it does is it creates a level of complexity and uncertainty that is unwarranted, that will not be effective. So,
On the complexity point, I honestly don't know the answer to this, and I suppose this is decided at the end game. But if Singapore and the United States and Australia and Canada and Mexico say, for purposes of certain parts of this, we consider this to be definitive and no longer our freestanding free trade arrangements, wouldn't that diminish the world's complexity? Wouldn't that be a good thing?
Well, in terms, I think in regards to diminishing complexity, if we're talking about harmonization, my knowledge of music is to a certain extent. It's not everyone in the same voice and the same pitch. That's not what harmonization is, and there's variation between them. I think that one effect is that you've got text that gets cut and paste, and you've got a country we don't know what to do about, internet service providers. Well, here's a chunk of text and throw it in your next digital law, and there you go. I think that's how it accelerates the maximizing of exclusive rights in countries just not ready for it.
Well, wait, what do you mean by that? Because Singapore cut and paste protection of internet service providers into their law from American law. That didn't maximize rights. That copyright holders are not happy about that, right? But Google said, I want this. And now the United States goes around saying you got to protect internet service providers, and American law protecting internet service providers gets cut and pasted into a bunch of jurisdictions.
Well, the problem with
Before we
Those
get
both
too frazzled, I don't know if you guys want to have a 30-second summation, and then we can wrap it up.
I do have a structural answer to your point, and you need to understand that two reasons this continues to happen, because your real question was, why are you continuing to negotiate IP standards when maybe the world hasn't digested everything that's been negotiated, which is certainly true. Two reasons. One, there is a cadre of people globally, in Ottawa, in Washington, in Geneva, in Brussels, in Tokyo, that's what we do. We negotiate treaties. Enforcement. So we get one treaty done, we're going to go on to the next one, all right? Good luck. Good luck to you. You're in charge of enforcement. All right, that's one reason it happens. Second reason it happens is corporate interests and civil society interests on their respective sides. They gain one victory, and they want to go on to the next, right? So we just negotiated a treaty on exceptions and limitations for the blind. Do you think that people who are advocates of exceptions and limitations, okay, let's pause and make sure everybody's implemented that fully, and then we'll wait till we go on to the next exceptions and limitations? No, of course not. Civil society is saying, all right, let's go on to the next set of exceptions and limitations. And same thing on the corporate side, the copyright people are saying, okay, we got some criminal enforcement, let's go to the next level of criminal enforcement. Got to be even-handed in the critique and analysis of how both sides do it.
Adon, 30 seconds, please.
In terms of even-handedness, the problem is that the USTR is trying to ratchet up exclusive rights and is sort of arguing for its clients. One example of this is when Israel actually incorporated fair use into their that helped them make it onto the special 301 list for implementing fair use in their law. So the problem is that it's only one-sided sort of aggressive negotiation, and that would be the problem when you're only cutting and pasting one half.
You want to have one final?
I think I've said what I need to say.
Okay, good. Well, that was a very interesting and fraught discussion. I thank you guys for your attention, and if we could show our appreciation to our panelists.
And we noticed in Canada. My reading is it just would impose a much stricter rules in taking them.
That's right. But, we might have had Singapore and Australia develop regimes of serious liability for the ISPs if they hadn't been stopped. Legal development.
But the USTR.
I take it you want us to get off the stage at some point?
USTR imposed this because, I'm not, I'm for fun blaming Google, because AT&T and Google and Yahoo said